Supreme Court of the United States has pronounced a judgment that might have far-reaching effects on the higher education as well as job prospects for Afro-Americans and other ethnic minorities in the country. In the line of fire were the oldest private and public institutions of higher education in USA, the Harvard University and the North Carolina University. Yesterday, the highest court of the USA struck down affirmative action policy that was being followed since decades during the admission procedures in US colleges. This particular decision might have a profound impact on the diversity of university student bodies and in American workplaces. In this video, we decode this affirmative action policy that has been held unconstitutional and what might be the possible repercussions of this drastic step. But before that, don't forget to like, share and subscribe to Oneindia. Let's start with the basic words in this context, the affirmative action. It also means positive discrimination. Affirmative action policy aimed to counter historical patterns of prejudice against individuals with certain identities. In the context of higher education, affirmative action typically referred to admissions policies that were aimed at increasing the number of Black, Hispanic and other minority students on campuses. In simple words, the aim of affirmative action policy was to increase the diversity of students. This ruling ends decades-long practice of affirmative action where universities would take race into account in order to improve diversity on their campuses. Such policies arose from the civil rights movement in the 1960s that had aimed to help address the legacy of discrimination in higher education against African Americans. In this particular case, affirmative action policy of two universities were in the dock, the Harvard University and the North Carolina University. The court decided two cases brought by Students for Fair Admissions, a group headed by Edward Bloom, a conservative legal strategist who has spent years fighting affirmative action. One case contended that Harvard's admissions policy unlawfully discriminated against Asian American applicants, while the other asserted that the University of North Carolina unlawfully discriminated against white and Asian American applicants. The litigants claimed that in the game of university admissions where the stakes are so high, such policies give rise to undue discrimination. The court ruled on a 6-3 vote in the Harvard case and 6-2 in the University of North Carolina that those policies by these two institutions indeed violated the Equal Protection Clause of the 14th Amendment. Chief Justice John Roberts wrote in the majority opinion that while affirmative action was well-intentioned and implemented in good faith, it cannot last forever and amounted to unconstitutional discrimination against others. The court said that universities were free to consider an applicant's background, whether, for example, they grew up experiencing racism, in weighing their application over more academically qualified students. But deciding primarily based on whether the applicant is white, Black or other is itself a form of racial discrimination. The dissenting liberal justices, including Ketanji Brown Jackson, the first Black woman appointed to the court, and Sonia Sotomayor, voiced their opposition to the ruling. They argued that the decision entrenched a superficial principle of color blindness in a society that still remains inherently segregated. At this point, it's imperative to wonder whether USA is the only country in the world to have such affirmative action policies in place. The answer is no. Several nations in the world have some form of affirmative action for student admissions into higher education. These policies may go by various names: affirmative action, reservations, alternative access, positive discrimination, but all mean the very same thing. For example, educational programs in South Africa not only admit underrepresented students, especially Black female students, but they also provide special courses and mentoring to facilitate those students' success. India also has caste-based reservations in education system. France and Brazil also have similar policies of positive discrimination. In fact, a lot of nations have programs to expand admission of students from minority groups on the basis of race, gender, ethnicity, class, geography or type of high school. This judgment has met with a diverse set of opinions. The conservatives are happy while the liberals are bemoaning this ruling. Harvard University is defiant, arguing that the role of diversity and difference in education is essential to academic excellence. In a statement, it has said that it would comply with the court's ruling, but it would force change in how it ensures a commitment to diversity. US President Joe Biden has expressed his strong disagreement with the recent ruling and has said that discrimination still exists in America and this decision cannot be the last word. Former President Barack Obama has also spoken out strongly against this judgment and has argued that these policies were essential to ensuring that all students, regardless of race or ethnicity, have the opportunity to succeed. On the other hand, former US President Donald Trump has hailed the decision as a great day for America. Republican Speaker of the House Kevin McCarthy has said that the decision now means that no American should be denied educational opportunities because of their race. This judgment is slated to almost certainly have a detrimental effect on the educational prospects of the students from ethnic minorities. Its effects could be gauged only after some time passes by. We hope you would like this new video. Thank you so much for watching.
Subscribe to Oneindia channel and never miss an update.